Title IX is set to get an overhaul as the Biden administration redefines biological sex for students in federally funded schools and universities. The administration's plan is to combat discrimination on the basis of gender identity and sexual orientation, and recently opened up those changes to public comment, which logged close to 350,000 responses. However, more than half of those disappeared from the record this weekend in a move the Education Department is calling a clerical error. Joining us to talk about this huge disparity in the numbers and why it matters is Sarah Parshall-Perry. She's a legal expert at the Heritage Foundation. Sarah, thanks for joining us tonight on Faith Nation.
Thanks for having me.
Well, first and foremost, you served in the Department of Education during the Trump administration. You've watched public comments to others' proposed rules. So what's your take on this large, even historic number of comments to this new rule on gender identity?
Well, I think it's telling we haven't heard anything from the Department of Education itself on a very significant disparity that arose between 24 and 36 hours from one day to the next. In a private correspondence with Politico, they indicated it was due to a clerical error on a comment that was not related to the current regulation under Title IX, and that it had resulted in duplication of almost 200,000 comments, which I find suspicious if they're not willing to publicly make an announcement or issue a press release to that effect. But I will say in the end, the regulation received somewhere between 210 and 235,000 comments, which is a historic high for any rulemaking process in any federal agency.
Well, Sarah, we know it's going to take months for administrators to sift through these comments and that there may be legal challenges. What kind of pushback are you expecting?
Well, we've already seen quite a number of lawsuits based on the intersection between Title IX and state sports laws, specifically to protect biological reality. Those challenges have been mounted either under state constitutions or under the federal constitution. But what we're likely to see, depending on the composition of Capitol Hill in both chambers after midterm elections, is potentially a joint resolution to disapprove of the letter. Under the Congressional Review Act, Congress has 60 days to issue a resolution essentially removing the law as if it was never proposed in the first place, which of course the president can veto. But then Capitol Hill, both chambers have an opportunity to override that veto. So it's entirely likely that this will be subject not only to state and federal law challenges, but to a congressional challenge as well.
Some potentially big changes coming on the horizon, Sarah. So what's your advice to parents who don't want these new gender rules in their children's schools?
I would say vote your values in November. Make sure that you are representing people who understand and will advocate for the nation's biological reality, what has always been the harbinger and the standard by which we judge civil rights protections in the country. I would say also be very active in your school boards and in your state boards of education, because those states are beginning to make their own rules on biological reality and have come out in opposition to the proposed Title IX rules, saying that they will not follow regardless of what the administration issues. So I would say to be vigilant and continue to hold fast to the notion of biological reality by being active in your own community and through your own educational avenues.
We're about running out of time here. 30 seconds with this last question here, Sarah. Supporters of the Title IX rule, they say that this change, the new interpretation, will ensure greater equality in employing LGBTQ workers. Is there a positive aspect to these changes?
Well, because those workers are already protected under Title VII of the Civil Rights Act, specifically related to employment discrimination, and post-Bostock versus Clayton County, the Supreme Court's decision in 2020, the court made very clear that they are to be protected under that federal civil rights law. They do not need a double protection under Title IX, which would upend everything we know about sex separation and equality in public education.
Sarah Parshall-Perry, unfortunately, that's all the time we have with the Heritage Foundation. Thank you so much for joining us tonight.
Thanks for having me.